Hello everyone, I hope you can hear me and see me. I'm Stephen Tromans. Welcome to Series 2, Episode 2 of our 39 from 39 webinar series. There are three of us, as you can see, myself, Celina and Dan. We've got some important issues in planning law. They're very, very current, some very recent cases, including just cases as recently as this week. So quite a lot to cover. I hope you're sitting comfortably in front of your screen at home. We'd obviously like it if you were with us in a room, but we hope you'll find this acceptable. And I'd just like to basically give you a little bit by way of some resources and a bit of information before we move on to Celina, who's going to begin. So we welcome questions, of course. If you can use the Q&A facility, I'm sure you're all very familiar with Q&A facilities from Zoom. Write in your question. We will try to answer it. If we can't answer it today, we'll come back to you at a later date. And we will do our very best to deliver value for you in terms of answering your queries. A few other 39 Essex resources. You may well be familiar with our website, not only for planning, environment and property, but the many other areas of expertise covered by members of Chambers. But if you're not, have a look, you'll find there newsletters, including our planning and environment and property newsletter, webinars, of which this of course is one. We have another webinar next week, Eastern Region webinar chaired by John Pugh-Smith. There are podcasts, there are vlogs, there are strange musings on video from people, and in particular, an innovation. You'll be receiving notification of this today, and it's going on our website today. We have our Planning, Environment and Property Winter Festival coming up, hence the photograph, the week commencing 7th of December, 7th to 9th of December, so 3 days of events, not all entirely serious, some quite fun events as well. We hope to be, as well as educating you, raising some money for Mind charity. So please look out for that, and we hope that you can join us for that, some or all of that winter festival at the start of December. The slides which you're looking at, you will be able to access. It'll probably be tomorrow morning now, but they'll be available on our website. So don't feel you have to scribble down lots of names of cases and so on. You will be able to access these for reference later. So with no more ado, I'm going to hand over to Celina, who is dealing with the first session. There we are, Planning Act 2008 and Challenges to National Policy Statements. So Celina.
Thank you very much, Stephen, and good afternoon, everybody. Thank you so much for joining us. I'm just going to do a quick session and an update on national policy statements. I apologise to those of you, and I did recognise a few familiar names who don't normally deal with DCO work. Yes, I am banging on about NSIPs again, but hopefully it may prove informative, but also it's an interesting contrast between how national policy statements work compared with the 1990 Act and local plan policy. I am going to deal with three parts. Firstly, just run through the basic law and process and role of NPS. I'm then going to look at 4 cases which are current and at various stages of decision. So there is no final decision in any of these 4. And lastly, I'm just going to look to see what the future holds for NPS and where we look at NPS in the overall scheme of climate change in particular. So Stephen is a master of slides, and if he could take us to the second one. So firstly, very quickly, the role of national policy statements. The source was the 2007 white paper, which came before the whole change and introduction of the 2008 Act. Their principal purpose, as I've set out there, was in order to have a clear infrastructure statement that would work, in effect, very much like the old roads programme policies would in the context of Highways Act procedures and orders. And the reason I say that, and it's not there, is because a lot of discussions that I had at the time when we were dealing with Terminal 5 and concerns were raised about why that was going on so long. Part of the discussions that I had with a few civil servants was, well, in roads, in roads orders, you deal with need as something that's established and it's not a matter for debate. And what you actually debate is the impact and where your roads are going to go. So there was a familiar tone to trying to introduce national policy statements and then to have the Planning Act 2008, which would take the new process forward. Thanks, Stephen. If we could have the next slide. Here are some of the ways that they are described. This is an extract from the white paper in terms of integrating the government's objectives for infrastructure capacity, etc., and environmental and social policy objectives, including, in particular, climate change goals and targets. And now this was some time ago that those were being looked at. So that has come back, in effect, as you will see later, to perhaps bite the governments in the bottom. Let's have the next slide, thanks. This is how they are described in far more detail on the National Infrastructure website, which is a very, very useful website for those of you who need to drop in and out of understanding where projects are and indeed during applications of DCOs. I'm not going to read it through, but it does set out quite how each of those NPSs are supposed to be, what they're supposed to reflect, and in particular, the fact that they may refer to a location or they might refer to a particular set of circumstances, but those particular circumstances and that particular location in itself is said not to provide the justification. You have to go well beyond that. The main thing, however, is need. Let's go to the next one. So frameworks for the NPS. Section 5 provides the principal process for designating NPSs. And clearly, like many other projects, they would have to be subject to sustainability appraisal and normally an SEA. Publicity requirements are set out in Section 7. And then at Section 9, after that consultation process, it goes, the draft NPS goes before Parliament for its scrutiny. Thanks. Then in terms of its scope, clearly, again, the Act reflects the fact that it should set out in relation to specified developments, that description, the amount, type or size of development and the description which is appropriate nationally or for a specified area. So that should underline the importance of what's in there. And indeed, at section 55C, it says that it enables policy in an NPS to determine the relative weight to be given to specific criteria. So the importance of the NPSs rather can't be emphasized enough. In terms of when you're designating an NPS, clearly the Act requires there to be given, for reasons to be given for those policy statements. So there has to be a supporting rationale. And then at section 5.8, an explanation of how the policy set out in there takes account of, again, mitigation and adaptation to climate change. Thanks, Stephen. Section 10 sets out the functions of the Secretary of State in terms of objectives, and then also, again, deals with climate change and how that should be mitigated and adapted to. Now, once you have an NPS, the process whereby you get updates to that is a review. Okay, so far so familiar from the 1990 Act process. However, there is no set time and no set process for that review. other than when the Secretary of State, who is obliged to review, but again, only when it's appropriate, or where the Secretary of State considered appropriate to do so. So on the one hand, it gives with one hand and takes away with the other. There are various criteria that are set out in subsection 3 to section 6, and I've set them out there. What in particular is key is whether there has been a significant change in circumstances to the basis of which policies come forward. Now, again, continuing theme here, and as you'll see later, a lot of these policies were designated at a time when climate change and net zero had not been set. So you can see that despite the fact that section 5 and section 6, section 5 makes it clear that climate change and how we would adapt to that and how we deal with it was part of the process, what has happened since is something that people have got very concerned about. In terms of what the process whereby you could alter some of the review and challenges, section 13 says it provides the basis for challenging the challenging the NPS once it's designated. That's that in itself. Section 11, interestingly enough, so this is in the context of whether you want to review, allows the Secretary of State to suspend part or all of an NPS, and it's treated as, in effect, withdrawn. Now, you can, as I say, you can suspend all of it, or indeed part of it, but that is something only that you can decide to do, you being the Secretary of State, based on the same criteria set out in section 6. So you have to find that significant change. Decision making. Now, this is where you can draw parallels with section 38, section 70 of the 90 Act, and indeed the NPPF, well, not so much the NPPF, but the section 104 provides the fact that the NPS is the fulcrum of the decision. The Secretary of State must have regard to the relevant NPS, and his decision must accord with the NPS, except when there are various exceptions to that. Those include, obviously, where there would be a breach of the UK's international obligations, or a duty that the Secretary of State has, or it makes it, or a decision in favour of this particular proposal would make it unlawful under a specific enactment. And lastly, again familiar for the 1990 Act process, if granting the DCO and allowing this proposal to go forward would have an adverse impact which would outweigh its benefits. So that's sort of typical planning balance exercise. Where you do not have a relevant NPS designated, section 105 applies, and that has a much more general process. The only things that you have to take into account are the local impact reports and important and relevant matters. Now, as I've said, if you compare this with section 38, section 70 of TCPA, clearly there's that planning balance exercise and the fact that you must accord with your policy. However, there is no policy out there or direction out there that under the PA08 process that says that you should treat an NPS as out of date just based on the length of its life. And that has been established through 3 particular cases, and I've listed them there: Thames Blue Green, Scarisbrick and SPURRIER, which was the Heathrow case. So that is an interesting context and contrast. I've listed there the current NPSs that we have. In particular, you will note that the energy NPSs, EN1 to EN6 were all designated in 2011. They are therefore, even for us older people, long in the tooth. And many things, as we know, have happened since their designation. The most recent one, interestingly enough, is the geological disposal for radioactive material. That was last year. However, the nuclear power NPS in particular, and Stephen will be able to confirm this, has a requirement date that, or is an aim date of 2025 for proposals, and that is fast upon us. So the EN6 in relation to nuclear power, as well as some of the other energy NPSs, are clearly already getting themselves out of date, and yet here we stand with these NPSs that are guiding current DCO schemes. The other one to note is the NPS reports, and I'll come back to that. So let's turn to the cases. Now, all these cases have a big thing in common, the continuing theme of climate change and how that is to be addressed in when you've got large infrastructure projects which clearly have impacts not only on basic climate change issues, but in particular GHGs. Now, SPURRIER, which was the original Heathrow challenge to the NPS, which was designated back in 2018. If we have the next slide, Stephen. The High Court clearly dismissed the challenge to designate this NPS. The Court of Appeal, as we all know, allowed that challenge, but on a very refined basis, which was in particular due to making the case that the government should have taken into account the Paris Agreement and the obligations that they say flow from that, and that was in effect a fundamental issue that should have been considered at the time and was not. The Department for Transport, the government conceded to the Court of Appeal's ruling on that, but Heathrow Airport did not, and they have literally just been in front of the Supreme Court to run their case that the Court of Appeal was wrong. And I watched some of it the other day, and indeed it's an interesting point that is being run, which is that the Paris Agreement, whilst of course it is binding as an international agreement, but what HAL have argued is that it's not policy. And if it's not policy, it doesn't have the same sort of materiality in decision-making and the designation of the NPS as other policies. So we will see what the Supreme Court makes of that. So that's still not clear on that. Now, forgive me all, I couldn't find a picture of a gas-powered power station, and given that I'm a Marvel fan, there's a nice picture of DRAX. However, if we go on to the next slide, DRAX was a DCO scheme for a gas power station, and interestingly, and once again, I'm afraid there are other examples of this, the examining authority recommended to refuse the DCO, and the Secretary of State, however, said no, she was willing to grant it. And at the seat of the debate that the examining authority had with itself, and which came before the High Court, was that that was actually the nature of the NPS and whether needed to be looked at, and in particular whether the issue of the need for this specific type of development. Mr. Justice Holgate was swift in his dismissal of this. However, what he largely concluded was that this was a merits challenge in disguise, and that was a challenge to the NPS itself, well, NPSs, but in particular EN1. I'm not going to go through all the grounds, but at the heart of this is the fact that whilst there was a significant adverse impact found in terms of GHG emissions from this proposal, that the Secretary of State was entitled to conclude in the way that she did, and that was supported by EN1 and 2, and Mr. Justice Holgate said she was entitled to do that. That has just come before the Court of Appeal, and I have to say, I'm sorry, I don't know when the judgment will be, but again, keep your eyes open for that, because that is going to be an important issue. If we go on to the next one, part of what came out of DRAX and all that debate was a recognition about the nature of EN1 and EN2 and how they are, in fact, getting a bit long in the tooth. And as a consequence of that, and other things, but as a consequence of that, the Good Law Project and a couple of environmental activists, I suppose they would like to call themselves, have taken forward a challenge to the government on the basis that there should be, and they have failed to carry out a review of all the energy NPSs. So if we go to the next slide, thanks. The government has said, well, not yet, and indeed what we are waiting for still, I'm afraid, is the Energy White Paper. However, during, again, the challenge and the communications that were had between the government and the challengers, they said, well, okay, government will look at these energy NPSs, and has made that a lot clearer, in effect, and that it wasn't going to be kicked into the long grass. What's happened now is that the claimants have said, well, okay, that's good news, but that's not really enough. Whilst there was going to be a rolled up hearing last month, it's now been put back to next year, January next year. An interesting proposal that's come out of that, however, is that the claimants have said, well, you don't necessarily, there are a number of options, and part of which, interestingly, is to suspend parts or all of those energy NPSs. That, however, would mean that DCOs coming forward would have to look at those proposals under Section 105, of course, and that might not be something that the government is willing to do. Now, the last, oh, sorry, not the last, yes, the last of the cases that I wanted to look at, this is not actually an NPS case. This is about RIS2. This is about the road infrastructure investment strategy. But it does have clear parallels, because if we go on to the next slide, you'll see it deals with the fact that there was, that in terms of timing and indeed in terms of effect, what the claimants are saying is that this RIS2 does not take into account, again, the net zero and the effects on climate change of increasing road construction. Where we've got to is that permission was granted by Mr. Justice Stephen back in July on one single point, which does relate to the climate change issue. However, there's been a recent reapplication for permission on a number of the other grounds, which go into all the other sort of environmental impact arenas, such as air quality and impact of air quality from, again, increased road building. So this is actually a more root and branch attack on road building per se, as opposed to the NPS cases that I've highlighted. Anyway, watch this space, as I say. What next? Well, we're still waiting, as I say, for the energy white paper. It was due in autumn, so cross fingers sometime soon, but clearly I think next year now. The government is saying that it's going to review those energy NPSs. Again, timing, we don't know. Now, I do, a little bird has told me that the ports NPS, which is definitely in need of review, especially given the dreaded Brexit, my understanding is that is also actually come up for review, but I couldn't find a formal statement to that effect. Risk 2, well, we'll see what happens with that. Nuclear, well, again, obviously that's part of the EN 1 to 6, but we'll see how nuclear facilities are dealt with, given that the clock is ticking. And lastly, we'll see what happens to the airports NPS, given the Supreme Court's decision that's going to be coming up. And just in terms of the implications of all this, it does strike me that there is an appetite, and has been an appetite for some time, for there to be wide-ranging issues raised against the government in terms of making sure that net zero and Paris are accorded with. And I'm afraid I don't think Boris's 10-point plan that he announced yesterday is really going to satisfy those who are activist and challenging this part of government policy. So that's me on NPSs. I'm very happy to answer any questions later. Thank you very much, Stephen.
Thank you for that, Celina. Well, while in most respects, it's obviously been a terrible year with the pandemic and COVID and so on. It's, on the other hand, been something of an exciting year in the realm of planning generally, but also in particular in relation to permitted development rights, a subject which perhaps might have been seen as something that might not have the capacity to be as exciting as it has been this year. Stephen, if you can switch to the next slide. My agenda for today, speaking about permitted development rights, is to speak, to first of all speak, obviously we're dealing here in the context of the wider government reforms of planning, and one plank of it, if you like, is the permitted development side, stemming from the government's document, Planning Reform, Planning for the Future, sorry, for this morning, Planning for the Future, which was issued in March. And then, of course, we've got the Planning White Paper on the other hand, which is working its way through consultation as we speak. But pursuant to the Planning for the Future documents, a whole suite of new permitted development rights have been issued over the course of the spring and summer. So I'll be looking at those briefly, and then looking at how, well, there's been two particularly significant cases and a couple of others that warrant mention in the past 12 months. So I'll look at those. And with perfect timing, as Stephen alluded to at the start, we've had this week the decision of the Divisional Court challenging the introduction of the new permitted development rights that were introduced by way of statutory instrument over the summer. So we'll look at those. So just a quick reminder then, I'm sure most of you are now familiar with the permitted development rights which have come in. The key ones, well, first of all, obviously in March, as we entered lockdown, the government introduced an amendment to Part 3 of the GPDO to allow food establishments basically to change use to takeaway, which many have taken up, as we know, with the sort of explosion of delivery type services. And those are in force for 12 months until March next year. As it stands, though, of course, they could be extended depending on the COVID situation. SI1 which was 632, that entered into force on the 1st of August. And that introduced a natural light requirement for dwelling house conversions and for the upward building or extension of on the top of blocks of flats of further residential development of either 1 or 2 stories, depending on the conditions and limitations. The second SI was 755, and that entered into force at the end of August. And that provided or made provision for further upward extension of other kinds of buildings. And then we've got SI3, and that also came in at the end of August, and that allowed the demolition of certain types of buildings, which can then be replaced by new forms of residential development. As I said at the start, the most important case, perhaps, of the last few months, then, is the case that we've had judgment handed down on Tuesday, and that was the Rights Community Action Challenge to the introduction of SIs 2 and 3 of my list of 3, and also of the amendments to the Use Classes Order to introduce a Class E. Which is beyond the scope of this talk, but obviously is also a very significant development. Those SIs have all been challenged. They've now obviously been heard. They were heard at a rolled up hearing in October, and judgment was handed down this week. The challenge was brought by a campaigning group, a loose group of campaigners and so on, who set themselves up as a public limited company for the purposes of the challenge, and it emerged really out of as a response to the controversy, which again I'm sure many of you have followed, regarding the previous, pre-COVID and previous introduction or amendments to the GPDO, really since 2013 or thereabouts. In progressive waves, allowing various changes of use to resi primarily. And the concerns have obviously related to conditions of accommodation, and particularly in terms of such things as natural light or space considerations. Thank you, Stephen, if we could. So the challenge was brought on 3 grounds. The first and perhaps the most significant ground, certainly in the way that the court dealt with the issues, was the ground 1, which was the challenge that, to the SIs on the basis that environmental assessments should have been carried out pursuant to the SEA directive and the SEA 2004 SEA regs. The second ground was an alleged failure to discharge the public sector equality duty. And the third ground was various failures, which were, it was argued, cumulative and significant, both together and also individually. Various failures regarding the consultation process, and also a failure to reconsult. So the divisional court, made up of Lord Justice Lewis and Mr. Justice Holgate, began, perhaps I thought it was interesting to note this. It began with a topical reminder of the limits of judicial review, and I guess in the context of what was clearly springing out of a campaigning group challenge. The courts obviously felt, not within the context of the various crises and conflicts between the courts and politicians of the last year, that they ought to remind everyone the limits or the proper role of the courts. So that was an interesting comment at the beginning of the judgment, and echoes some of the issues that Celina was discussing in relation to MPSs and so on, and climate change, of course, which is a prime topical issue of that type. Ground 1 then, well, the court set out 4 criteria derived from the directive and the 2004 regulations, which it said needed to be satisfied. Now, the first 2 of those criteria it was common ground that were satisfied. So the issue became, in the case, whether criterion 3 and criterion 4 were satisfied. And those were whether the plan or programme set the framework, whether this was a plan, whether these SIs were, or the GPDO as amended, was a plan or programme setting the framework for future development consents of projects. That was it, criterion 3, and criterion 4 was whether the plan or programme, if it was a plan or programme consistent with criterion 3, whether it would then be likely to have significant environmental effects. The court held ultimately that criterion 3 wasn't satisfied. This wasn't, the GPDO isn't in fact a plan or programme setting the framework for future development consents. It is in fact, and the court here was looking at judgments like the Keenan judgment, which some of you may remember, which was an agricultural building case. But Lord Justice Lindblom in that case made clear for the Court of Appeal that the GPDO grants permission by Article 3(1). It is not, the grant doesn't come about through the particular limitations or conditions of each part, but rather is granted by virtue of the Article 3, subject in certain cases to various conditions and limitations, including prior approval, where that comes in. And the key debate really was whether prior approval in particular, although also all of the other conditions and limitations could be said to set a framework, if you like, for future development consents of projects. And the court found, again, consistently with Keenan, that no, it did not. Issue 4, however, had the court decided that the GPDO was such a plan or programme, then the court did say that the Secretary of State would have had to have screened, undertaken a screening assessment, if you like, and made a screening decision as to 4. Grounds 2 and 3 were ultimately not held to be as meritorious. Ground 2 in particular, the claimant alleged a failure in relation to the public sector equality duty, and in particular a failure to consider the needs of elderly and disabled people in relation to some of the proposals or some of the provisions enacted. Permission for that ground was refused in the context that this was a rolled up hearing, and the court found that the duty had been complied with at the consultation stage because public sector equality duties matters had been highlighted for the purposes of the consultation, and then subsequently the responses, such as they were on those issues, had been considered. An assessment, an EIA or an EQIA had been produced. And then thirdly, and crucially, all of those issues and all those matters had been put to the minister before the decision had been made. So there was no basis for that ground, and the court did refuse permission as well as dismissing it. Ground 3, here there was a series of alleged failures in relation to consultation and failures to reconsult alleged. And the court found, again, no merit in most of them. It held that consultation had taken place. In particular, there was a complaint that particular expert reports which had been produced in advance of the consultation procedure, which had preceded the introduction of the SIs, the advice given in those reports had not been followed. And finally, that there'd been a failure to reconsult despite clear precedent in the case of 5G, where there had been reconsultation, and also a promise in particular in relation to SI3 of a reconsultation. And again, the court found no merit in any of those issues. Particularly, the point that may have carried some merit in the court's view, or at least was arguable and was granted permission, was the potential for reconsultation. But again, the court held there that wasn't made out in the end. The circumstances here were very different to 5G, so there was no precedent. And importantly, although there had maybe been a promise of reconsultation specifically in relation to SI3, the COVID context provided, well, the court actually held that there had been insufficient argument really on the point about legitimate expectation or whether there had been one. But secondly, and importantly, the COVID context provided a clear proportionality rationale behind the decision to resile, if there had been such a resilement, from the promise to reconsult. So altogether then the court dismissed the challenge. Just before getting to New World Payphones, I'll just mention we do know, or we do hear, I should say, the permission to appeal is being sought in the Rights Community Action Challenge, so we should watch this space on that. And I suspect there is argument still to be had, potentially at least in relation to ground one. The second major case then of the year in terms of PD rights was the New World Payphones case. This was a case heard in the Court of Appeal, Lord Justice Hickinbottom giving the court's judgment on Part 16 in relation to telephone apparatus. Part 16, or Class A of Part 16, permits electronic communications code operators to install, alter or replace communications apparatus. But the problem in this case was that the kiosk included on it, as is presumably quite common from looking around London, but the kiosk included on it an illuminated integrated back panel advert. Prior approval had been necessary for citing an appearance and had been duly applied for. Stephen, if we could, thank you. It had been refused by the local planning authority on visual amenity and street clutter grounds, and also, interestingly, it had been refused on grounds of need or a lack of need. That decision had been overturned on appeal by the inspector, and then it went to the High Court, where Mr. Justice Ouseley, before he retired, determined that it had fallen outside the relevant class because the kiosk had a dual purpose, and so therefore couldn't come within the class, and therefore wasn't permitted development, and so that the Court of Appeal, well, sorry, then the Court of, sorry, that need also the additional grounds that the LPA had refused on was not relevant in this context. The Court of Appeal, again, Lord Justice Hickinbottom, that agreed with Mr. Justice Ouseley and relied on, in part, on Keenan. But I think there's an interesting point raised in this case. Lord Justice Hickinbottom, amongst other things, in quite a long judgment, said, paragraph 49, on an application to an authority for a determination as to whether its prior approval is required, then the authority is bound to consider whether its prior approval is required. Sorry, then the authority is bound to consider and determine whether the development otherwise falls within the definitional scope of this particular class of permitted development. Now, I just raised the question here. This does seem to cut against what is said in Keenan and another agricultural buildings case, Marshall, where the opposite is said. And in fact, in Marshall in particular, it is said that it's precisely not what the local planning authority should be doing. They shouldn't be considering and determining that issue, although they should, where appropriate, give their opinion about compliance with the class. So anyway, that's an interesting question about which approach is right, or whether it's simply a case of looking at each part and not reading across from other parts across the GPDO. So finally then on case law, just I wanted to highlight a couple of points which are really on procedural matters. The first is the Coventry Gliding Club case. This was a barn to resi conversion under Class Q, and the issue in the case really was about whether there'd been proper notification under paragraph W of Part 3. The court held that there hadn't been. The site notice had been erected some 100 metres or so away from the site, and that had been inadequate, and the court therefore quashed the decision. I understand on that, Mr. Justice Swift giving the judgment, there will be a further hearing on remedy, which will look at the question of what happens in the context of a failure such as that in terms of the parties' respective rights. So we should look out for that, about whether development can proceed or what the status of the decision notice was, notwithstanding that it had been quashed for the procedural error. The second case, again, another one going to the Court of Appeal, is the case of Gluck, a case in which our own Philippa Jackson's involved. There is a challenge there, and again, to a refusal of prior approval. And the question in the case was whether objectively speaking, on an analysis of what had taken place, had the local planning authority and the developer, or could they have been said to have agreed an extension of time? The issue will be obviously considered by the Court of Appeal, but there's already been an amendment now to ensure that that is possible, because obviously in many cases it makes practical sense. So finally then, just some lessons which we do find repeatedly come up really in the cases. It's very important in PD cases, obviously, to understand the process, to understand the roles, respective roles of parties and a developer and a local planning authority, or indeed if you're someone who's interested in whether something's going to take place. Particular things to look out for, obviously, if you're a developer, you need to be paying close attention to what the submission requirements might be under any particular part in order to satisfy the requirements of the GPDO. Local planning authorities must pay similar attention to those requirements, making sure that they're following the procedures correctly, and also considering their wider duties, such as the possible or powers, such as the power to consider introducing an Article 4 direction limiting PD rights. It's again worth just repeating, because it is a constant theme throughout the cases. Each part must be considered with great care. The court will ultimately determine the meaning of the language in the statutory instrument, and it is important to take great care about what the class says and whether you come within it. Otherwise, obviously, you could end up with enforcement problems. I'm going to end there, but I just want, before I hand over to Stephen finally, I just want to say, in relation to the introduction of the SIs, the PD changes that came in over the summer, our colleague Catherine Barnes has given a very good summary presentation with a series of slides outlining all of that in summary form for you. I haven't repeated that all here for time constraints purposes, but it is available on our website, and it's a very good one to look at if you just want to have a quick summary of what's happened. So thank you very much, everyone, for listening, and obviously I can answer questions as well if there are any towards the end, and I'll hand over to Stephen.
Many thanks to you both. I think there are a few questions that have come in, Dan, on the chat function or Q&A. So maybe I'll ask you and Celina if you can have a look at those whilst I'm speaking and see if you can deal with any of them, or we can perhaps pick it up at the end. I'll move on to the final presentation, which I'm doing, a quartet of cases. So this brings together 4 cases in the Supreme Court and Court of Appeal, which we've had during the course of the year, some very recent cases. And I'm showing you there the door 19 Silver Street, Department of Land Economy at Cambridge University, which is where I started my legal career, really, teaching law there. Interesting thing about teaching law in the Land Economy Department was you've got to teach aspects of land law which are quite different to what you cover in the law tripos. So a lot of emphasis on things like restrictive covenants, planning, agricultural holdings, all of those things. So a lot of these cases take me back on a bit of a trip down memory lane, really. So I'm happy about that. I'm very kind of nostalgic these days. Anyway, there we are. The common theme, I would say, with all these cases is that they represent potential flies in the ointment. They're all really to do with problems which can occur in the course of trying to build out development. You think you've got a great scheme, you've got planning permission, etc., are there flies in the ointment at a practical level which can get in the way of a successful completion and wreck the entire endeavour, as the caption there says. So the first case is a Supreme Court decision reported in the Times just yesterday, actually, although it's been around for a little while. Alexander Devine and Housing Solutions Limited. This case was to do with Section 84 of the Law of Property Act. Restrictive covenants are, of course, private property law rights. They are not to do with planning as such. They can be used to protect positive obligations, for example, requirements to pay overage if those are contractually given. But Section 84 of the Law of Property Act 1925 provides a regime where restrictive covenants can be either discharged or modified. That's been around for a long time. It's been amended a little bit over the years. And the test, one of the tests is the covenant now contrary to the public interest? So is it the case that the continued existence would impede some reasonable use of the land for public or private purposes, or, as the case may be, would do so unless modified? And in Section 84 1A B, you look at whether in impeding reasonable use of the restriction is contrary to the public interest, and in considering that question, the upper tribunal must take into account the development plan and any declared or ascertainable pattern for the grant or refusal of planning permissions in the relevant areas. So there is a statutory link with planning, effectively. So the facts, planning permission was given for the development conditional on the provision of affordable housing. That development was inappropriate for the Greenbelt and contrary to the development plan, but special circumstances justified the grant of permission. It was effectively a mixed use type of development. It was next door. I think yes, just missed a slide out there. Sorry, I'll going back to the previous slide. We're talking about Greenbelt land. There was a 1972 conveyance with a restrictive covenant which protected an overage obligation, which in fact had expired, which prohibited building and restricted the use to open space for parking. A developer applied for planning permission on the land burdened by that covenant to build affordable housing units, and that was linked to an application to build housing units for commercial sale, as well as for affordable housing. Sorry, I'm getting a bit out of control here with my, just bear with me a minute. My clicker is going a little awry, sometimes does. So as I was saying, planning permission had been granted for permission for the development, for that development. The developer was aware of the restrictive covenant and could have chosen, and this is important, to lay out its development so as to honour the covenant. They could have laid out the scheme so that the covenant would have been respected. They chose actually not to do that for whatever reason, and that's, we'll come back to that, that's quite important. So the developer continued to develop despite objections from the dominant owner. The developer then applied to the upper tribunal for discharge of the covenant. The upper tribunal held that the restrictive covenant should be modified to permit the occupation and the use of the land, but the developer was to pay to the owner of the benefit of the covenant £150,000 as compensation. The Court of Appeal disagreed and allowed the appeal. Sales Lord Justice Sales gave the sole judgment in the Court of Appeal. Lord Burrows gave the judgment in the Supreme Court, the only judgment, unanimous decision by the Supreme Court. The question was whether there was a cynical breach, effectively? This was a key question for the Supreme Court. Effectively, had there been a deliberate breach of the restrictive covenant with a view to making profit? And the Supreme Court said that this was a relevant factor for the exercise of the discretion of the upper tribunal in deciding whether or not to modify or discharge the covenant. And the two factors which the upper tribunal had not addressed were, first of all, that the developer could, as I said earlier, have submitted an alternative plan, which would avoid that problem. And secondly, the developer had created the state of affairs which they were complaining about, i.e. housing units that had been constructed and now couldn't be occupied in the first place, by a deliberate breach of the covenant, by pursuing a scheme for development which had built deliberately on that area which should have been kept clear, which it wasn't actually necessary so to do. And it's been said that it's been said by Martin Dixon in the Conveyancer that this is just desserts, basically. The Supreme Court has reasserted that it's clear that proprietary obligations are exactly that, and they're not to be disregarded just because it becomes inconvenient. The case raises some, I'm skipping on because we're short of time anyway, broader issues of the relationship between private rights and public interest. And there have been some cases on this in recent years, Lawrence and Fenn Tigers, and the more recent case about the Tate Modern with its viewing gallery overlooking the flats next door. It will be interesting to see, actually, now that the covenant has not been modified, what happens when the owner of the covenant tries to enforce it, because we still have that issue. What remedy is going to be given to enforce it at common law? But there we are. I think that's quite an interesting topic, actually, to keep an eye on. Very important, I think, for developers. There's a very good article by David Sawtell of my colleague in Chambers on this, if you want to read it on our website. Second case, DB Symmetry and Swindon Borough Council. Richard Harwood of our Chambers was involved in this. Can a condition require land to be dedicated as a highway? This was a scheme which was part of a major development to the northeast of Swindon, known as the New Eastern Villages. A major issue was transport connectivity to the A420 road was a key issue there. The permission, application documents together with the permission identified the access road as highways for interconnection with the rest of the development. And there was a condition, which I won't read out, but you can see there, to do with the access roads being constructed in a particular manner to ensure they are an adequate means of access and a functional highway. And the question which flowed from that was really essentially a private law dispute between the relevant owners of different parts of the development. The subsequent developer, a company called Symmetry, claimed that the access roads didn't have to be highways open to the public, and therefore they could charge other developers for access to the rest of that road network. So a pretty fundamental point. And this was determined by a certificate of lawfulness process. The certificate of lawfulness was granted on appeal, that the roads could only be built, the roads could be built on the basis they were private only, didn't have to be dedicated as highways. That was quashed by the first instance judge, Mr. Justice Andrews, who said that the highways were required to be dedicated. Secretary of State didn't appeal that, but Symmetry did appeal it successfully in the Court of Appeal. And as with some other cases we've mentioned, a permission to appeal has been submitted to the Supreme Court. So we're not necessarily at the end of the road, as it were, on this one. So what did the condition mean? Well, the Court of Appeal said that really the most natural meaning of condition 39, which you've seen, was that the highways had to be dedicated. The problem with that was that if that were the case, the condition would be unlawful, because on old authority, Hall and Shoreham-on-Sea 1964, planning conditions can't actually lawfully do that. They can't require effectively private property rights to be expropriated. And so the court applied the so-called validation principle that, quotes, a realistic lawful interpretation is to be preferred over and above one which results in a situation of unlawfulness. And the approach put forward by Symmetry was realistic, it was said. The condition only required the roads to be built. It didn't require their dedication. The condition didn't refer to dedication or public rights itself. It wouldn't have been clear anyway which parts of the road network precisely were to be dedicated. There were a lot of areas of road which were turning circles and things like that. They didn't necessarily have to be dedicated. And also importantly, the planning permission was to be construed as not derogating from private rights, which would include forbidding access to roads. So the final point, again, a very important one, is the court said, well, if this is what had been intended to be achieved, then there were well-established means for achieving it through Section 38 of the Highways Act on dedication and or Section 106 obligation. They had not been used, and therefore the condition was construed in the way Symmetry suggested, so it was able to charge others for use of those roads. Next case, nice picture of Snowdonia. That's not the area involved in the case, just to cheer us up a bit on a lockdown. Nice to have some good scenery to look at. Hillside Parks and Snowdonia National Park Authority, case about issue estoppel and the effect of a master plan. Quite an important case, I would say, from that point of view. The application was for planning permission for 400 dwellings made back in 1967, so an old permission. It had been granted subject to a master plan showing the proposed siting of those dwellings and various roads. That had been varied over the years. There had been a dispute in 1985, a trial in front of Mr. Justice Drake, and that judge back then had granted a declaration that development had been begun and could be lawfully completed. And in 2017, the local planning authority disagreed and said, no, the development can no longer be completed lawfully because basically the roads and the houses have been constructed in the wrong place, so it's impossible now to build out the remainder of it consistently with the master plan. The developer owner didn't like that and relied upon what Mr. Justice Drake had said in 1985. And there were a number of issues there. These are wonderful cases I remember so well from the 1980s. Really not heard much from them since, but they've returned. So cases like Thrasivelu on issue estoppel. Could the developer rely on issue estoppel in relation to 1985 judgment? Held no. The facts had moved on, the law had moved on. There was no longer an estoppel to be found. In particular, as I said, it was no longer physically possible to build out the development in accordance with the master plan. However, the developer relied on this older case, even 1964, F. Lucas and Dorking, where Mr. Justice Wynne, well-known planning judge in those days, had held that a 1952 permission authorised what he called partial development. In other words, you could build it out in bits. The developer tried to rely on that case. The Court of Appeal, whilst not overruling it, regarded it as an exceptional case turning on its own fact, which is sort of a polite way of saying they think it's wrong, really, but don't go quite as far as to say that, and adopted a more modern approach of a case called Singh and Secretary of State in 2010, where it was said that under modern planning, a more integrated or integral approach is likely. Schemes come forward with master plans involving highways, landscaping, community uses, other uses, open space, and the developer doesn't have an ability to just pick and choose and build out some bits, but not others. So that's actually quite an important authority, I think, in relation to old permissions, which may be subject to a master plan of some sort. There's another interesting point, which is what happens in relation to development which already has occurred. but really couldn't have occurred lawfully because it wasn't in accordance with the master plan. The court really left that for another day as to what the enforcement position would be, but one can see that coming back maybe in future. If you look on our website this coming week, our Planning and Environment newsletter has an article note by me on this very case, which you can read if you want a more leisurely canter through it. And my final case, Smith and Castle Point, this to do with intensification and contamination issues, both potentially quite important issues these days. The facts were that planning permission had been given for not a scrapyard itself. The scrapyard had been there and had permission for many years, but the permission was for a 5-metre high concrete boundary wall around it. The scrapyard had been granted permission in 2002. There was no condition requiring any restriction on the height of the waste stored in the scrapyard, but the waste management licence granted by the Environment Agency restricted the height of the waste to 5 metres. An adjoining owner of land which was had mixed use permission said that the permission on the wall implicitly allowed intensification of the use of the scrapyard, and also argued that the land was contaminated and there had been an inadequate assessment of contamination. They submitted their own contamination assessment in support of that. On contamination and pollution control, the case is quite useful, up-to-date discussion of the position as between pollution control systems and planning, reaffirming lots of earlier but now quite old cases that planning must assume that the pollution control systems will work, and the planning officer in his report had been quite justifiable in referring to the ability of adjoining owners to complain to the Environment Agency about amenity impacts from the scrapyard, and the Environment Agency doing something about that under waste management licensing or environmental permitting. But the top bullet point also made the important point that neither national nor local guidance on contamination was really geared up to this situation. They're really concerned with changing the use of land from old gasworks to residential development or something like that. This was something quite different, to do with simply building a wall, and there was no requirement according to those policy documents for any further assessment of contamination. And on intensification, again, another lovely old case that I remember quite well teaching, Penwith and Secretary of State, where a factory had been extended, and the point of the extension was to allow the factory to operate much more round-the-clock basis and essentially allow intensification, which justified the imposition of an hour's condition restricting the operation of the factory. However, the Court of Appeal here didn't follow the Penwith case. They said it was wholly unclear how the implication of intensification would arise. There was no basis on which a condition limiting the original permission was to have been imposed simply because the boundary wall was now being given planning permission. And Dan and Tom, sorry, referred to as Tom, but Tom van der Kloeg of our chambers were counsel for the successful respondent in that case. And if you look at, again, our website, they have written a piece in our newsletter on that if you want to read it in greater detail. Thanks very much for being with us. We'll come on to questions in a minute, but it's been great. We've had so many people, we've had over 100 people attending this event on and off, which has been terrific. So look up what's coming. As I said, next week we have on Tuesday the 24th at 2:30 an Eastern region update, chaired entirely different presenters and indeed entirely different subject matter, so no repetition of this, chaired by John Pugh Smith with John Darby, David Sawtell and Catherine Barnes. So you may wish to watch that whether you're in the Eastern region or not, frankly. And of course, as I said, our wonderful winter festival, which is forthcoming. So I've been concentrating on presenting myself, so I'm not aware of what's happening on questions, but I'll hand over to Celina and Dan. Are there any questions that have come up that you'd like to address, say anything by way of further thoughts that occur to you? Over to you.
Indeed,
Yes.
not surprisingly, I'll quickly do this. I'll introduce. Dan and I have been having exchanges over the phone, and they're largely to do with stuff that Dan's been talking about. So I'm just going to step right back and let him answer.
Okay.
Well, I think there's one which is probably quite quick to answer and quite simple, which is there's a question asked about the Rights Community Action case and whether, given that permission to appeal is being sought, what might be the potential impact of that application on the SIs for the moment. And I mean, the position will be that they remain in force until and unless the Court of Appeal intervenes, or indeed, the Supreme Court intervenes to quash. So I think that's the position, and obviously, I mean, I don't know about you two, but I mean, in my view, I thought that there was potentially some fertile ground there for a possible appeal, at least in relation to ground one. Although, of course, we'll have to wait and see if that goes anywhere.
Yeah.
So that was the first question. I don't know if either of you want to chip in on that, but
The question.
No,
Go on, Stephen.
No, I'm just saying I'm content with that, but you carry on.
The quick one I had was that given the conclusions about it not being a plan or programme, and that reminds me of that case, and I've forgotten the name of it for the moment, where DARF decided that the NPEPF wasn't a plan or programme. What happens, I wondered, when you have other development orders that grant permission, but in effect clearly are granting permission for a specific site and area, and why that wouldn't be a plan or programme? I don't know whether anybody has thoughts on that.
Go on, Dan.
Yeah. Well, I was going to say. I mean, I think that the thrust of the judgment, certainly, and the way that it's been set out, quite comprehensively setting out the statutory framework, and so on, going back to the 1990 Act, as you'd expect, but dealing with the powers in that Act that give rise to the ability to make development orders, you would think that they would be found similarly not to be plans or programmes on the same line of reasoning. On the other hand, a specific proposal would perhaps be possibly a different of sorts. But I mean, I think there'd probably be some room for debate. But I
just thought if a development order is actually granting planning permission, then we're into the realm of sort of development consent, aren't we? Probably rather than actual strategic environmental assessment. So it probably needs to be subject to
EIA. Yeah, absolutely.
Yeah.
Absolutely. So it will be subject to EIA, but not S.
Yeah. Okay. Anything else? I mean, it just does occur. I mean, it's interesting, isn't it? The number of challenges coming forward. It seems to me that we've got almost unique conditions for vast numbers of challenges coming forward, where it's rules on standing are very, very lax. It's very easy for new groups to mushroom and spring up. I mean, many of these groups we've heard mentioned today, they're not the traditional Friends of the Earth or Greenpeace. They are very often quite ad hoc groups. Also, with the rules on costs, there's really very little risk to them in terms of bringing a challenge, and B, crowdfunding means that large sums of money can be raised almost instantly anyway, in ways that have been quite inconceivable a few years ago. So we've got all these conditions favouring action, but again, we've got a pretty resistant, I think, body of judges holding the line and making the were mentioned about these shouldn't be merits challenges. There's got to be you've got to find some unlawfulness there somewhere, which isn't actually all that easy to do.
I think that's right, Stephen. And I mean, the only sort of slight point to temper that I think would be that I mean, on Aarhus costs, for example, I think that as you say, the judges are resistant. There seems to be some move. At least I've seen a few examples now, and I can think of one particular example that was quite shocking to us, where the caps have been varied actually to a level where it seemed pretty harsh actually within the context of a COVID scenario. So, I mean, but I agree generally. You're right. I think that some of the conditions are there for challenges. On the other hand, some of the issues are very, very important, and perhaps there's a flowering of the type of particularly environmental issues that it's inevitable in a sense, as Celina was alluding to in terms of the national policy statements. These are big issues, and it's I suppose the courts are going to grapple with them just like any other arena, if you like. Great.
I'm going to tread carefully because I'm not really allowed to talk about JR generally at the moment.
Oh, no, you're very
much on IRL, but very interesting, and I'm listening.
Yeah. Okay. So, well, I'm sure at some point you'll be able to talk about it, Celina, and we look forward to hearing from you once you're released from your purdah on that. So, I hope it's been helpful to you all. Thanks for sticking with it and with us. If you do have any further questions, feed them in somehow to us. I'm sure there's ways you can do that, and we'll do our best to deal with them. But we hope that you'll join our webinar next week, and we'll see you early December as well. So I'll say cheerio for now. It was a lovely afternoon when this started. It's gone a bit grey now, but maybe you've got a bit of chance for a bit of fresh air before the end of the day. So stay well, and we'll see you soon. Bye for now.
Thank you very much. Bye.
Bye-bye, everyone.
Bye.